right, we'll start up in a minute. No cameras do not need to be on in this case because it's a webinar. I don't even believe we have a function for having your cameras be on. I'm not 100% sure if we even have that tool for available for us. It looks like some of the people that were registrants still aren't getting links, so I'm not 100% sure how we're going to get those messages out to folks. But Katie, I will leave that in your capable hands. And you know what? Let's just get this show on the road. So this is the 2025 updates to the Oregon Realtors forms. So each year our goal is to update the forms once to twice a year. Ideally, it'll be twice at kind of clean intervals. January or so and August or so would be kind of the points in time where we will update forms. Each of those corresponds with some time after we've had our last forum, where we get feedback from membership about at our conventions about basically what worked, what didn't work, what needs to change, and all that. But this is our first set of updates for 2025. These come from user comments, they come from the forums, they come from principal broker forums that we have across the state, it comes from task force input from our forms task force, and it comes from attorney review. Basically, our goal in most of these situations is to gather as much information as possible and address concerns that exist, review the legal hotline messages and see if there's anything within the forms that's causing problems, and listen when people are saying that things could be improved. As a result, we have some forms that are undergoing major updates. These are specifically the contingent right to purchase, the delivery and receipt of association documents addendum, as well as there's a new form for short sales. Our preference would have been that short sale documents don't need to be drafted, but as the economy gets odder and odder, short sales are becoming more common and more necessary, and so we've added that form to the library. These changes will go live January 1st on the various platforms. That's what we're being told. They've told us that number before and it has not been delivered on, so assume January 1st unless we tell you otherwise. There are also some forms that are going to have minor updates, so that's all the sales agreements are going to undergo some minor updates. The notice of intent is going to have a slight change. The association addendum, the representation agreements are going to have minor changes. Referral agreements as well as the advisories are all having minor update and additions and changes to them. But we start with Form 2.10. So this is the contingent right to purchase addendum. First chunk is not a huge change, but it is what it is. When we previously updated the contingent right to purchase addendum, we added an option in there for what happens if you have a sale where the buyer who is offering to purchase the seller's house is presently under contract to sell their own buyer property. And so a situation where the contingent right to purchase was not quite drafted ideally on that scenario. Originally, a contingent right to purchase idea is the buyer puts in their offer and they say, don't worry, I'll list my house. And when somebody wants to buy it, then I'll let you know. And my financing will be ready to go. What happens a lot of times is the buyer is already under contract when they find the house they want to purchase. And the process that existed previously was you would send in your contingent right to purchase with your offer, and then you would simultaneously provide a notice of intent and say, not only do I have an offer for you to buy your house, but I'm already under contract on my present property. And we added a provision that basically just did that for you. It was a one-step process rather than having to kind of arbitrarily add the contingent right to purchase, the notice of intent, and say, not only is my offer good, I also am under contract. What we had in that was if you did say, here's my offer, I am under contract presently, a fair amount of the contingent right to purchase document didn't apply. This line 23, sections 6 through 11 of the addendum had no effect. Section 4 also needed to be added. There was no purpose for it because if you're already under contract, then the contingency deadline no longer matters. So that's been added onto it. It theoretically didn't have a significant change on the process, but for clarity's sake, we've added that as something that is removed. Now, where the real change comes is this whole thing. This section 11 is the new version. The previous variant of the contingent right to purchase had timelines begin upon mutual acceptance. And the premise of it was if you signed your sales agreement with a contingent right to purchase, you would plan your timelines accordingly so that you would have a contingent right to purchase that says, look, I'm going to try and sell my house for 30 days, and then I also want 10 days of due diligence. So once my house is sold, and I know I've got the money secured, then I want my 10 days for diligence. So you would plan those timelines accordingly. Putting it all in one place wasn't necessarily the most user-friendly, and so we've deviated out to, you have these options, checkbox options. The first is exactly what it was previously. Timelines begin as stated in the sales agreement. It just is what it is in the sales agreement. The next version is this, addition is this line 65 through 69. The due diligence period begins as indicated when the buyer delivers their notice of intent. The appraisal deadline begins either at the end of the due diligence period or within X number of days after delivery of the notice of intent. Now, this is somewhat different. If you've seen, for instance, on the OREF contingent right to purchase addendum, its statement is essentially all timelines begin after delivery of the notice of intent. The issue we ran into is there are some timelines that should not begin at delivery of notice of intent, some that just have to begin at mutual acceptance, such as the seller's property disclosure statement, like revocation period of time, as well as the lead hazard, lead paint period that you're given under federal law. Those can't or should not be delayed as kind of a matter of course. And so what we've got instead is the due diligence period is the mobile point that's waiting for the notice of intent where the buyer says, I'm ready to move forward in my contract, and the appraisal deadline can be moved accordingly as well. We also have this line 70 for other, so if you just have some other wild change that you want to do to the timelines for your contingent right to purchase, that option now exists. So where before it was all baked in, it was kind of set in stone, there are now multiple options for how you begin your timelines when you have a contingent right to purchase on a sales agreement. 4.4a is the delivery and receipt of association documents. This has been updated somewhat to include the option of does not exist more clearly. We had the situations that would occur where essentially someone would send in their association addendum and they would say, I want the bylaws, I want tax documents, I want the following information in association documents, and some might not exist. And our preference is just to make it more straightforward. If you can't get a hold of that document, there should be a way to be able to explain, hey, these documents don't exist. Now, normally there was a statement that you would provide in this 4.4a. You would say, I don't have 12 months of tax documents because the association's only been in existence for 8 months. So 12 months worth of these documents don't exist. But rather than just writing it out, now we have check boxes where in the delivery and receipt of association documents, when you deliver the documents as a seller, you would check, I've delivered the codes and covenants, I've delivered the association rules and regulations, the articles of incorporation, delivered, compilation of all association approved resolutions, delivered, copy of meeting minutes from the previous 12 months, does not exist. And you would explain that does not exist, but it's a more streamlined and clarified version of being able to explain when a document simply is not present. Now I see some Q&A and I'll check that as well. Mike Curlinger asks, due diligence period, oh, this is back in the contingent right to purchase scenario. Due diligence to begin upon buyer's delivery. If I deliver form 2.11 on Monday, is Monday the first day or does it begin the next? All timelines will begin the next day. So that's the one that's baked into the sales agreement itself. So if something says we begin the timeline upon XYZ, it starts the next day. And the day is decided based on essentially whether you're doing business or calendar days. So in this case, where we're dealing with calendar or business days, it would begin the next business day. So if you deliver Form 2.11 on a Friday, the first day of that timeline begins on the following Monday. If you deliver it on a Monday and Tuesday is a business day, it would begin on the next business day. So it essentially is the next day, but that's more baked into the definitional terms of the sales agreement than it is into the individual addendums. The new form, and this is kind of the major change, is the short sale addendum. So short sales, broadly speaking, if you haven't done one before, they are distressed transactions at best. A short sale is where you have a property that is for sale where the purchase price may be less than the amount of the various liens and mortgages that are attached to that property. So there may be mortgages, credit, judgments, lawsuit, liens from construction, all kinds of stuff could be applied to this property. And if those combination of liens outruns the purchase price, you may have a situation where the sale of the property is not going to cover all of those liens. And so short sale documents are a manner for the seller to essentially go up to all the creditors and say, look, I want to sell my property. It is way underwater right now. There is too much debt on this property. Can we negotiate some process where I pay you less than the amount secured by your lien off this purchase price? So I'm going to sell my house, and I may only be able to pay you back 80% of what I owe you. And if all of the lenders are on board with that, all the creditors are on board with that, they in some cases will say, yes, debtor, we would much prefer that we just get this off our books as bad debt and just write off a small portion rather than have to deal with foreclosing a property. Foreclosure is not a fun process. It simply is not. As an attorney that used to do foreclosures, that it's difficult, timely, time consuming, and takes a significant amount of time. And so a lot of lenders will actually, not all of them, but many lenders will see a short sale as potentially an opportunity, not to guarantee that it will happen, but something that it's not all bad. But they are very complicated transactions. The seller in these situations, we begin the document in our short sale addendum by basically saying this is what a short sale is. Seller, you acknowledge that the debts with lien holders may not entirely be forgiven, and at the end of this sale, you may be responsible for the difference between what you're able to pay that lien holder and what you owed them originally. So it's possible that a lien holder will say, yeah, I'm fine with you selling your property and paying off most of your debt, but I expect you to pay the remaining piece. In the end, it ends up being a much more negotiated transaction, and so there are quite a few moving parts that could be found depending on what the lenders allow or don't allow. There are always other options that might be more advisable than actually selling, such as bankruptcy, where you have a homestead exemption and you might be able to keep your property, different loan programs, refinancing, revised payment plans, loan modification, getting a deed in lieu of foreclosure rather than having to go through the foreclosure process itself, or some sort of an individual lien holder might have a mitigation program for these sort of distressed properties transaction scenarios. If that's the case, it may be better to have the seller go through one of these other processes than to go through a short sale. And so we do notify that at the start of it. We essentially say, hey, be aware, seller, there's all kinds of other options. Maybe look into this and maybe consult like a tax professional or an attorney before you necessarily fire away on doing a short sale. Check the Q&A one more time before I move forward on that. The next section of the short sale is the mandatory lien holder disclosure. So prior to mutual acceptance of the addendum, before the parties can agree to actually doing a short sale, the seller needs to provide a list to the buyer that describes the names and contact information of all the lien holders and, to the best of the seller's ability and knowledge, how much the seller owes that lien holder. Basically, before you even get your short sale addendum accepted, the seller has to tell buyer, hey, here are all the people that have liens on the property. Here's how much I owe them. And buyer, this is my best guess. I haven't necessarily consulted them, so I can't guarantee that these are accurate numbers. The seller also needs to submit complete sales agreements, all the documents to the lien holder, all of the lien holders that may be there, along with this short sale addendum and any other documents that are required by the lien holder to approve this short sale. What this basically means is if you are doing a short sale, the lender or the lien holder has to also say, I'm okay with this short sale on the terms that you are doing. A lender can theoretically say, I don't approve of this, and that could stop the entire transaction. Lien holders, be they mortgage holders, judgment creditors, someone that sued you because you crashed into their car and it attached to your property after they got an order from the court, whatever it ends up being, they don't have to approve of the short sale and can instead say no. And if they say no, it may stop you from being able to do that short sale because you simply don't have the liquid assets to be able to pay off all of the creditors, and in the end that would be a much more detrimental process for the seller to sell property and then be significantly underwater after the fact. So seller says it needs to tell everybody here's what the terms are for the short sale, and if the lender wants any other documents, seller's supposed to provide it as quickly as possible, promptly within a couple business days if it is required. The seller also is supposed to instruct the lien holder to provide approval status updates to the buyer upon request. So basically they can say, lien holder, let the buyer know where we are on this, please, because the buyer has a vested interest in knowing whether we can move forward on this short sale or not. Someone says I'm cutting out badly. That is, before I proceed, is this for everybody or is that just for that one? How's my audio, folks? Okay. Okay, so it may just be that one individual, but that's good intel because I'm glad we're not recording something where I sound like a robot. So the next section, this is arguably the most important portion of a short sale addendum, but like that's not to say that any one portion is more important than others. The lien holder's approval. So when a seller goes into a short sale process, they have to get approval of the short sale from all the lien holders. They are supposed to deliver written notice to the buyer that says all the lien holders are happy with this transaction, and I too am happy with all the terms that the lien holders have applied. Lien holders can sometimes approve the terms of the transaction and request modifications. They can say, yeah, I love that sales transaction, but like you really need to get the following extra things added to your transaction. The buyer should be paying for the following closing costs, not you. And if that's the case, the seller has the right to also say, look, the lien holders just applied terms that I can't abide by, and so I can't make this happen. And so if you look in other states, at times it'll just be a requirement that the lien holders give permission. The way we've written ours is the lien holders need to approve, and then the seller needs to approve the modified terms that the lien holders have created, if any modified terms are created. Once you have that approval notice, once the buyer has received it, that basically says all of the lien holders are on board and the seller's on board. Everybody except the buyer is on board at this point. The buyer has the right to terminate if they don't want to be a part of this anymore. So the buyer has a right at any time to basically say this is just not going to work for me, because the short sale is there are risks involved and there are modifications that are involved. And so for the remainder of the transaction, the buyer has a right to back out of the transaction and get their earnest money back. The seller will have until a specific date to provide that approval notice. If they do not provide it by that date, then for the remainder of the transaction, either party can back out of the contract. What this essentially means is if one of the lien holders is just sandbagging their approval, the buyer or the seller can say, this isn't working out, I'm sorry, I'm going to have to find a different house. Or the seller can say, I'm going to have to find a different way of being able to do this, because maybe such and such the judgment creditor is not going to be approving this sale, and I don't want to keep stringing this along and creating more expense. So if someone doesn't make this approval deadline, both parties can back out of the transaction. Now, if this sounds like we're creating a transaction that's on somewhat pillars of sand, that is true, and that's intentional, because the short sale is an incredible risk, and so we don't want the parties to be locked in necessarily on some of these extraordinary risk transaction scenarios if there is something that is in third-party control that could end the transaction, such as a lien holder that just doesn't want to provide approval. We're not going to force the parties to kind of march forward in some sort of a mortis dance till they get to the very end of the process, and then the lien holder finally says no and the whole thing falls apart. So there is an approval deadline. If you don't receive full approval by that point, both parties can say it's not working and end the transaction. If a lien holder does withdraw approval, seller has to tell buyer very shortly, promptly, as soon as possible, or within 2 business days, tell them that a lien holder has withdrawn approval. That's very important to know. There's also a checkbox option where the seller can set it up as a triggering event that sets off all other timelines and deadlines in the contract. So you're in much the same way that the contingent right to purchase can set up a triggering deadline that says, once this event happens, now my timelines start, and now I have the obligation to do due diligence and all those things. The same can be true here. You can check the box and say, look, until seller gets approval from all the people, all the lenders, we're not going to do anything in this transaction. We're basically not under contract. There is no assurance that a lien holder or a lender will approve of the short sale. So just parties need to be aware, if they're in a short sale, the lien holder can withhold their approval for any reason and all reasons. They don't have to even give a reason for why they're withholding their approval. You do need to be aware that a lien holder can literally at any time just say, I know I gave approval of the short sale, but nonetheless I'm going to foreclose on the property, and that can cause problems. At all times, the lien holder can request a copy of all offers the seller receives. They can demand that the seller continue marketing. They can do all kinds of things to make this a more complicated transaction. They can require modification of terms and basically say, seller, if you don't modify the contract in the following ways, I'm not going to approve of it. And that is valid under the law in this situation, because essentially the lender is being asked to forgive debt that they validly incurred, or that the seller incurred, and the lien holder does not have to give approval lightly. The seller and the seller's agent are not liable for delays that are caused by the lien holder in this situation, so we put that in there as well. And liens that are held by an FHA or a guarantee from the VA may require a seller payment of forgiven amounts, so we just understand that that's the case. And the parties are not obligated to modify the contract or consent to modifications required by the lien holder. So, in the same way that the lien holder can withhold consent or demand modifications of the contract, if there are modifications of the contract demanded, the parties don't have to march forward with it. But they do understand that if they refuse to allow those modifications where the lien holder is withholding their approval based on those changes, it could result in the full failure of the transaction. So, it is a dangerous zero-sum game to be involved in. And the buyer understands that if they are expending money on inspections, repairs, or otherwise, that could be lost if a lien holder just suddenly withdraws their approval. Let's see. Patrick says normally the addendum would be presented with an offer to purchase if it's a short sale, right? Why? How would the seller provide lien holder information prior to acceptance of the offer? Generally, they should provide it prior to acceptance of the offer. However, there are some instances where the parties will go under contract while still awaiting approval from the various parties, and so that's kind of the broad difference there. Wouldn't it be better to have the seller deliver a written notice of short sale approval? Line 40 says shot sale. That's trouble. That is very correct. That is true. That says shot sale. We will make that update before these go live in January. That is a typo. Thank you for noting that. We'll get that updated. Section 8, continued marketing. So this is one where there is an option that can exist or not exist. If the box is checked, the seller can continue to market the property as an active listing until the seller delivers their approval notice to the buyer. So some lenders may say, seller, you got to keep on accepting offers and keep marketing the property until we give all the lien holders give approval. If that's the case, the seller can essentially continue to submit offers to the lien holders for consideration, and the lien holder may require the seller to essentially back out of their present offer and accept one of these other offers if they deem it better. Generally, the lender will want the highest and best price so that they lose the least of their investment. And so in some cases, they will have the power to essentially say this transaction is only valid if you keep marketing and accepting offers, and I want you to accept the one with the highest dollar value no matter what. And if that's the case, buyers should be aware you're in a somewhat thin ice transaction. There's also the checkbox option, which says that seller may accept backup offers to purchase the property conditioned on termination of this transaction. So if they do wish to have backup offers, we can also make that something that's an option in here. Foreclosure, to the best of seller's knowledge, there either is or isn't a foreclosure on the property. If a foreclosure has been filed, it's not necessarily going to change the transaction itself, but it does change the positioning of the parties in a negotiation because you're essentially on a ticking time clock. And if that clock expires, then the foreclosure may just happen and there will be an auction and the seller will lose their rights and interest in the property. And at that point, your transaction has failed. If a foreclosure does occur, the seller needs to tell the buyer as soon as possible, and the transaction is done. You don't have a transaction anymore after a foreclosure, and there's really no way around that, with essentially the exception of if the seller somehow does a credit bid at the auction and now owns the property. But at that point, we would prefer you just don't do a short sale anymore and just do a sale. Mike says, first checkbox in Section 8 essentially indicates that the lien holder gets to decide which offer will be in first position upon delivery and approval notice. Functionally, yeah. Patrick says, for phraseology, delivery should be shall rather than may. In this instance, either one would be the option. In this case, because the lien holder is essentially mandating that process, if they do say, seller, you have to, then for all intents and purposes, that is a shall based on the lender's side. But in this instance, we put it as a may because it could be an option where the parties put that out there without necessarily having a mandate from the lien holder. But it is something to take under consideration whether to make this a strictly mandatory term rather than something that says may. So that's short sale stuff. From there, we just have minor updates and minor modifications. So short sales, broadly speaking, it's an adaptation on the form which basically says this seller may not own the property in the future and the seller's ability to sell may not be the seller's own decision. It can be used if you are in a short sale scenario. I wouldn't say it's something you want to just smush into any old transaction you can because it does get complicated fast and it involves a more nuanced understanding of the party's obligations and the party's various requirements under law in this situation. There's a minor update to all the sales agreements, specifically this definition of business day. Previously, it was any day other than Saturday, Sunday, or a legal state holiday under ORS 187010. Now it is any other day other than Saturday, Sunday, a federal holiday, or a legal state holiday under ORS 187010. The original reason why we didn't have the word federal holiday was because there was complication where parties would go, how do I know what holidays count and which ones don't? And so we decided on a one-stop shop, which was you can figure out exactly what holidays you're dealing with. In this case, 187010, it will always be the state's holidays. The problem is Columbus Day is the one day where the federal government has made it a holiday and the state has not. And so there was this awkward divide where on a certain day each October, you would have a federal holiday that happened, but a state holiday did not. And so we've updated it to include that federal holiday to essentially capture the Columbus Day problem. Now, this does not necessarily solve every issue that exists with the concept of business days. For instance, the day after Thanksgiving is neither a federal holiday nor a state holiday. Now, if you look it up and you say, what are the state holidays? The first thing that will pop up on Google is the Public Utility Commission website, which says here are the state holiday closures, and they include the day of Thanksgiving and the day after Thanksgiving. That is not a state holiday. That is the day when the Public Utilities Commission is closed. Now, for whatever reason, they are the first thing that pops up on Google, but that only means that the Public Utilities Commission office is closed on the day after Thanksgiving. The rest of the state does not consider that a state holiday. Now, under Oregon administrative laws, essentially on the executive branch, most agencies in the state have decided the day after Thanksgiving is a holiday for their agency's purposes, but it's never been added as a legal state holiday. And so we can't necessarily impose some sort of a definition on that says, any legal state holiday plus the day after Thanksgiving, because some businesses will be open, some will not. Some agencies may be open the day after Thanksgiving, some may not. The original goal of having a one-stop shop has been deviated from quite a ways now, but at least we've covered Columbus Day. So business days, for our purposes from now on, any day other than Saturday, Sunday, a federal holiday, or a legal state holiday, and you can look at the statute to find what state holidays are. The sales agreement also have had some modifications to the dispute resolution provisions, specifically this first chunk on lines 425 through 426, that has been removed. It previously said unless you would take it to Arbitration Services of Portland for mediation services, if there's some mediation that has to go on between the parties, unless a buyer or seller's agent is a member of the Portland Metro Association of Realtors, in which case you take the mediation to PMAR's mediation program. Now, PMAR shuttered its mediation program, so they send people to Arbitration Services of Portland anyways, so we can remove that provision and there's no technical loss. But for a short period of time, there was this separate program of mediation that existed at the local association level, specifically at PMAR. Beyond that, on lines 440 to 441, if there is an issue that needs to be resolved under Article 17 of the Code of Ethics, the parties agree to arbitrate the issue and be bound by the resulting arbitration or award. This is essentially because in Article 17 arbitrations between two or more brokers on something, for instance, like an open listing, where the client has the ability to initiate the arbitration and then bring the two brokers in to basically hash out their dispute over who's entitled to commission, there is only some sort of a bindingness to that arbitration if the client has approved of the arbitration. So we've baked that approval of the Article 17 arbitration into the contracts themselves. Generally, you're not going to see that many Article 17 arbitrations, particularly when brokers are readily using exclusive agency agreements. But sometimes you will have situations where you still have Article 17 arbitrations that exist where the client is equally involved to a certain extent. OR.gov's own website. So Doug, check what that one is. It's usually or.gov/PUC. That's the one that's the Public Utilities Commission. Because the Public Utilities Commission is a portion of Oregon's government, it does pop up and makes it look like it's the original actual government website. The technical answer is the actual days for holidays. It's going to be, so DAS is Department of Administrative Services. That's the one that tells you when the various agencies declare their own holidays. And that's one where the government of Oregon has decided for its own purposes that the day after Thanksgiving is a holiday, but the rest of the state doesn't consider it to be a holiday because ORS 187010 is the only place where federal or state holidays are defined for like the broad public writ large. So in that case, it's administratively the government of Oregon likes to consider it a holiday, but it's simply not at a legal level, and that is not necessarily going to be imposed on, for example, like title companies or inspection companies, those kind of things. They may be open the day after Thanksgiving as well. 1.2, so this is the commercial purchase and sale agreement. It has undergone an update as well. Previously, it stated buyer's signature below and the delivery of the offer to the seller makes this an offer. And if the buyer wishes to include an expiration date, they should include it in the additional provisions. The idea originally was essentially that these commercial transactions oftentimes have quite a few moving parts, and they quite oftentimes have quite a bit of due diligence that leads up to the actual acceptance of an offer, where parties are doing a fair amount of backtracking research to find out whether they find this commercial purchase to be a good one or not. And so as a result, having a strict, hard and fast deadline that had to keep on getting amended seemed kind of irrelevant for a lot of commercial brokers. Because they essentially said it's nice to be able to have the option, but I also like not having to update the contract every single time that we miss the deadline because someone is looking into another like esoteric piece of consideration for that commercial transaction. That was not super popular, so what we've done instead is put back in, there's an expiration date. So commercial contracts, they expire now. So if you have an irregular contract with some sort of a commercial transaction where you're trying to have your offer accepted and it looks like you're getting close to that expiration date, you need to extend that expiration date. Make sure you do it intentionally before it expires. If an offer expires, it's not valid anymore. You can't accept an expired offer. You would have to make an offer anew. Generally, expiration is treated as something that essentially explodes the offer, like one of those Mission Impossible recordings that just goes up in flames after it is played. So when you hit your expiration date, the contract is done. It can't be accepted. You can counteroffer on that, no problem, and do a new counteroffer, and that'll make a valid offer in its own right because counteroffers are offers. But once something expires, it's done. And so what that means is because the commercial transactions now have a strict expiration date that will be written into the contract, if you approach that expiration date and your buyer wishes for their offer to remain live and actionable, you will have to intentionally expand and extend out that expiration date and don't let it expire, because once it expires, you have to set up essentially a new offer. The notice of intent, this is the companion document to the seller, the contingent right to purchase. It has undergone a visual modification and some minor modification to essentially change around some of the language to make it more clear what applies to what. So we now have these nice bold black lines that say, if seller providing notice, seller fills in only the below sections. If buyers providing this notice, they only fill in the below section. So it'll make it more clear, basically like you only have to fill out this chunk if you are a buyer, and only this chunk if you are a seller. Doug, to your question, yes, it is exceedingly confusing and it is frustrating. And it essentially is a situation where you have a state governance that has applied its own rules for holidays, but a legislature that has not followed. And so while those are executive branch holidays for most executive agencies, the legislature has not followed in suit. It's along the same lines as like why we still have, for example, like daylight savings, even though the legislature has approved of it. And it's because other legislatures have not. And so, even though one group may think one way, until everybody does, you don't have an actual law that passes on that process. And so the day after Thanksgiving should probably be a holiday for most purposes, but it's not in the statute. It's just not, it's not part of the law. The notice of intent also has these additional pieces. So specifically, release of contingencies does not modify the sales agreement terms outside applying a requirement for proof of funds. So if you're a buyer that says, I'm under a contingent right to purchase, normally I'm supposed to sell my house, it's just not moving, but I have enough money to buy the house anyways. I don't know, the buyer is independently wealthy for whatever reason or something like that. And the buyer says, I just don't need this to sell my house anymore. So this contingent right to purchase, I don't need it. It would have been nice, but I don't need it. They can release that contingency, and all of the terms of the sales agreement remain the same, with the exception of the rights that are created in the contingent right to purchase for a proof of cash funds or otherwise some kind of a proof of financing. We just added that in. Now, I think originally that would also be the case. It would be very clear in most kind of contract disputes that all the terms of the contract remain the same because you have not modified them, but we put it in writing expressly because confusion did arise at times over whether or not the remaining contract was the same when you did release all of your various contract rights through the notice of intent. We also removed all of the shading from the buyer's intent to terminate. To make it more obvious that when you're choosing your option on your notice of intent, you have three options. It's not two separate sections and you would fill in an option accordingly. It would be your options are, I intend to proceed, I'm under contract, my house is going to sell, and that will finance this. I intend to release my contingencies. I intend to proceed, however, my house is not selling and I will finance this property otherwise. Or I intend to terminate. My contract is not working out with my house right now. I'm not going to have the financing. I can't make this purchase. I have to be out of this contract. And so the buyer has those three options and they're not shaded to make them look different because that was creating some confusion where people would say, like, I checked a box on section 10, but what am I supposed to do on this next section that's shaded here? You would choose one of the three options to proceed, release, or terminate. On the association addendum, there has been a minor update to basically add clarity to a little bit of clarity to what broad laws things apply under. So, for instance, when we talk about a planned community, what we're talking about is a planned community under ORS 94, which is a defined term under the statute. Now, it's a broadly defined term, and that means that there is a little bit more law that's mashed into this, but planned community can get messy fast, where it's this thing where it's like, what is a planned community? Because you got like an architectural community, or it's a homeowners association architectural group. That's kind of a planned community, right? Like it's sort of a homeowners association. Well, in this case, no. We're saying strictly the things that are established under ORS 94, or a condo association under ORS 100. It's not a lot more clarity in essence because we just don't want to impose a huge amount of legalese on this somewhat advisory section of the contract itself. But it at least provides a little bit more guidance than the broadness of a term like a condo association, where there is some meaning, but the meaning needs to be understood with a little bit more fine-toothed of a comb. On the association addendum as well, we've added some what I've described as null set options. These are the things that don't exist. If they don't exist, what do you do? And so in the general information section, where you're providing information about the association, what's the association's name? What's the management company, if any? If there isn't one, you don't fill it out. Now that was the case beforehand, but now it's saying if any makes it a little bit more obvious that you have the option to say none exists, or NA. And then the seller owns or leases a parking space, a storage space, a slip space, a home park space, whatever it ends up being. You also can just check a box that says none. None applies. NA. This is not applicable to me. So if you have a seller in a homeowner association or planned community, whatever it ends up being, and they have neither a parking space nor a storage space, you can check a box that basically says this doesn't apply to me. So it makes it a little bit less aggressive to just leave things blank. You're given an option to check to show the null option, the non-applicable set. The association addendum also has this little chunk here where it's not actually adding a huge amount of, it's not new information, it's just referencing out to the Form 4.4a that we talked about earlier, the delivery and receipt of association documents document. Where it basically says if the documents don't exist, you provide Form 4.4a and you list the documents that you can't provide in the space provided. So you just check the box that says does not exist and tell them why. It's additional explanation. It doesn't change the rules at all. It just tells you kind of more of how to use the sister document to the association addendum. Let's see. Mike asks back on the contingent right to purchase notice of intent. Is the first option in section 9 notice of intent still present, indicating the buyer has accepted the offer but not released all contingencies? Yes. I just didn't add it to the slide because I have limited real estate to put on the PowerPoint. But yeah, there would be in the actual form, there's a third checkbox above this one that says, I'm under contract, I accepted an offer, yay, I'll let you know if it falls apart. And so that third option does still exist. I just didn't have it present on the slide, and it hasn't been modified in any way. It's still exactly the same writing it was before. Let's see. The agency agreements have undergone minor changes based on House Bill 4058. So there was a bill that was passed, House Bill 4058. It modified wholesaling, real estate wholesaling. It modified a handful of other elements of real estate business transactions and business practices. In general, the big thing that applied to residential real estate is essentially that you now need representation agreements, written representation agreements starting January 1st, 2025. It also established a rulemaking requirement on OREA to basically say, tell us more about what these written agreements should look like. And from prospective rulemaking that we've gotten from OREA that is likely going to be the kind of final version of the rule, they're asking now that the representation agreements and agency-related documents also have the broker's license number as well as the principal broker's contact information. So we've added in the license number and the phone number for the principal broker onto all of the agency-related documents, essentially because now it's going to be part of Oregon administrative rule that we'll have to do that. There was a minor update to the dispute resolution provisions as well. One thing that shouldn't have been there, but it was, is there are certain things that are excluded from the dispute resolution provision of an agency document, such as if it's a probate dispute, if it's a bankruptcy dispute. And we also said small claims, but the previous provision, this section 18 says, hey, if it goes to small claims court, take it to small claims court. So it made no sense why we would have a provision that said take it to small claims court if it can go to small claims court and then say don't follow the previous rule. So we took that little chunk out, which basically says if the dispute can go to small claims court, take it there. We've also added the section in there that says we agree to arbitrate if it's under Article 17. It's an Article 17 issue. If it can be exclusively resolved under Article 17, it will be done so. And we will be bound to that resulting award or agreement. So we kind of mixed that in to address the Article 17 requirement through NAR. The buyer representation agreement, there is a change as well that's been modified. The buyer's acquisition within 180 days, there's an entitlement, in some cases it's called a holdover provision, where an agent is entitled to compensation if there is a purchase that happens based on information the agent has provided. The agent has essentially done the service that entitles them to commission. And in this instance, we set it up as a unilateral termination, but in this case, we're making it more specific. It's when the client unilaterally terminates. When the agent unilaterally terminates, there's no holdover. You can quit on your client, that's fine, but when the client unilaterally terminates, that's when a holdover provision applies, so that the agent is not able to essentially benefit from being able to terminate on a client and then also claw back compensation from a holdover. When you are the one doing a unilateral termination, you've simply cut the cord, you've cut the fishing line, and you can proceed, you can move on, but it is what it is. The other change is on this line 7677. There is a term that is the preceding sentence does not apply when a buyer unilaterally terminates. So there is a provision that essentially says if there is a subsequent representation agreement that is signed with another broker, the buyer doesn't have to pay both agents in that situation. They only pay one commission, and then the agents would essentially arbitrate over who is entitled to that. That does not apply if the buyer is the one unilaterally terminating, they just quit on the contract. Then in that case, we go to section 10, which is the termination section. Previously, it said this provision does not apply, which was in reference to that line 74 through 76. However, there were people that were going, well, when it says this provision, does that not mean the entire section? And the answer is no, just line 74 through 76, the provision. But we've just changed the language around to make it more clear what it is in reference to. The previous sentence is the one that doesn't apply. On the referral agreement, there's a minor addition on there where there's an optional expiration date that can be added to your referral. So there's a little checkbox and you can check it and it says this referral is only valid until blank date. Now, if that is not present, generally the referral is going to be valid for what would be any contract would be valid for, which is the reasonable amount of time given the circumstances and the contract itself. Now, in the situation of like a referral of a client, that usually it would be an uncertain amount of time that is typically representative of how long an agent represents a client. That is what you are referring out to someone. There are some comments that we've gotten from people where they have referral agreements from like 30 years ago and someone comes out of the woodworks and says, this is enforceable and I want my referral. It's probably not going to work that way. I think if that was ever actually litigated in a court of law, it would be something where they would say, this is, no, your referral was only for that one client and that client service for that client ended some time ago. But you can now put in an expiration date for the referral. Just be aware it's optional and doesn't have to be there. So there's still the ability to have kind of the hanging abstract referral time frame. On the advisories, this is the last minor update that's been added to the library. The short sale advisory language has been expanded. It's been made more robust for the buyer advisory to essentially say, there was previously some language that talked about short sales. We've added a significant amount more, basically saying, here's what a short sale does, here's the risk that's involved. You can also use, this form is the one that we have in the Oregon Realtors library that addresses it. If you're going to do a short sale, be aware there's a whole bunch of risks involved, and so we've expanded the advisory language about short sales out a fair amount, and done the same for the seller advisory. We've expanded the advisory language around short sales and made it more seller directed. Things, for instance, where like this last paragraph, hey seller, you should know debt that is forgiven in a short sale process might be considered income, and you might suddenly have a surprise tax bill at the end of this process. So just be cautious in this process. Your real estate licensee can give you marketing information and whatnot, but you really should probably talk to an attorney or an accountant if you're curious about the more esoteric legal or financial ramifications of a short sale. And so the buyer and seller advisory both have short sale language that has been added to it, and in each instance the language added is more specific to the individual party that receives that advisory. There's more buyer-centric short sale documentation and more seller-centric short sale documentation that is added. And that's what we've got. Those are the updates. This is where question time pops in. I'll check the Q&A and see what we have in there, if there are things that I have not addressed yet. I see from Rick, on the purchase and sale agreement, section 4 is where seller concessions are identified. The text size is very small when inserting a dollar number versus a percentage of the purchase price. It'd be easy to miss a request for closing costs. Can that line be reformatted so that the dollar amount is bigger and more readable? We can work on it. We have a little bit of real estate we can move around in the various forms for formatting, so that's something that we can definitely look into. So yeah, we'll make a note of it. But otherwise, those are our form updates. Not a significant number. The main big change is the addition of a short sale document and short sale advisory language, but otherwise relatively stable. If you got questions, this is the time to do it. I am going to babble for the next 5 minutes to fulfill our 1 hour of CE requirement because we need 50 minutes. So questions are welcomed, always. Otherwise, I'll just chatter about some of the process that goes into these things. So as hopefully people are writing their wonderful questions that will give us another 5 minutes of CE, it is worth noting that these forms updates, they come from a wide array of sources, and we would always prefer to have more input from people where possible. So if possible, if you would like to provide feedback, forms@OregonRealtors.org. Let us know what works and what doesn't. If you wish to, send us a contact at forms@OregonRealtors and let us know you want to be on a forms committee, and we can set up our forms task force. We can add people to it as the interest arises. We are always looking for more input on these because we would like to be able to see a significant amount of broker input onto these forms to make it more valuable and useful for your practices themselves. I see Debbie says, I'm confused about Columbus Day being a holiday or not. So Debbie, this is a wild one. Columbus Day is a holiday at a federal level. It is not a holiday under Oregon state law, much in the same way that Oregon allows you to use marijuana and not be illegal, like an illicit drug in Oregon. However, it's illegal at a federal level. The Fed and the state have sometimes different and at times non-congruent laws, and that's what's going on with the holiday of Columbus Day. It is a federal holiday, which means federal branch offices will be closed down. It means banks will generally be closed because they can't really contact the Treasury or get things like done through with federal connections. Fannie Mae, Freddie Mac, they're not going to be operating on Columbus Day, so it does create some complications there. But as far as the state of Oregon is concerned, it's not a holiday, and therefore many of the state agencies and state offices will still be open on those days. And so what we've done instead is basically just said under Oregon Realtors forms, Columbus Day is now not a business day because we included federal holidays. Otherwise, they overlap in most places. Relevant state statute specifically referenced in the form 187010. So ORS 187010 is where the legislature defines the various holidays. 187020 is where the governor can declare holidays. To my understanding, Kotek has never declared a holiday in her time as a governor. She's declared some days that are like worth notice and like applies some sort of a like public eye or scrutiny on certain events or issues, but has not yet used the gavel as a governor to essentially create a holiday. So ORS 187010 is where you're going to have to go to find state holidays as they are defined by the legislature. Christopher says, not too important, but with buyer broker agreements only being able to last 2 years in length, how is that broker referral agreement can be open in length? What that essentially means is because it doesn't have a fixed deadline at common law, we establish the deadline is whatever the reasonable amount of time would be. Because buyer broker agreements in the state of Oregon can no longer exist for more than 2 years at a time without individual input, what that basically means is your referral agreements will also have a 2-year maximum timeline on them for how long they can exist, because that is how long any representation of a buyer could reasonably exist in that one like iteration, that one tick of a representation of a client. To answer the question, Chris, we have not added a strict timeline to it, but because the law has changed, so too has the standard at common law for what a reasonable maximum length to a representation agreement could be. And so 2 years is kind of the deadline or the maximum ceiling on a representation agreement, a referral agreement, unless you've stated otherwise. Is it true that the day after Thanksgiving can't be a state holiday because banks can't be closed for 4 days in a row? I am not 100% on that, but that would make a fair amount of sense. Given the new state requirement for signing buyer representation agreements, will be some form of advisory to give potential buyer clients that explains the law and our responsibilities under it. Yes, to a certain extent, that could be done. The issue we do run into in a fair number of situations is that the advisory language is subject to change until we know what OREA is specifically putting out in front of us. But our plan is at some stage to have an advisory that we can present that basically says this is what the law requires of us under the representation world. It just hasn't been fixed in stone yet. Is there presumably there's an increase in short sales statewide? Is there a reason for adding the short sale addendum? Yeah, we don't have an extraordinary amount of data that we go off of, but the implication from commentary we've received is that short sales are becoming more common. So it's not something where I can say like we talked to escrow and escrow has told us exactly how many transactions have been short sales. However, from what we've heard from brokers, more short sales are going on, and we've gotten more requests from brokers asking for short sale addendums. So the assumption we've created from that is essentially it seems like short sales are becoming a little bit more common, and that does seem to track on essentially how the economy has been treating people. When there is less money going around for the average person and housing prices keep going up, it is more difficult to stay in housing. As a result, short sales are probably becoming more common just in kind of a logical stance. And that code number is printed in the form. Yes, on all the sales agreements it says business day in the definitions section. I believe it's section 36, but don't quote me on the section numbering. It'll say in various definitions business day defined, and it'll say any day other than Saturday, Sunday. Now it'll say a federal holiday or a state holiday under ORS 187010. Bob asks, in the short sale process, the form did not seem to recognize that past lenders took months to respond. How would that be handled in the forms that require lender approval? If you are asking for lender approval and it takes months, it will typically take you well outside the scope of like time frame you put on your short sale addendum. So there is a drop dead approval date where we're basically saying by this day we expect to have approval from all the parties. And if a lender has not gotten back to you by that point, both parties can back out of the contract. The buyer or the seller can basically say it's not working out. I'm not hearing back from the lender, and I can't do the short sale without their approval. So in essence, the way it would be handled in the form would be either you provide exactly the amount of time that you're expecting to have before a party wants to back out, or if you know how long these lenders will take and they take months, you would plan your approval deadline months out so that you've got that kind of that much space, that much runway to actually get that short sale full approval. Person is asking if a client wants to work with a broker past the 2-year deadline, is that allowed? Yes, it is allowed. However, you are only able to have a representation agreement that goes for a 2-year period at a time, which means you can renew that agreement after that, the 2-year mark, and put another 2 years on it, but you can't have automatically renewing agreements or agreements that go for 3, 4, 5 years. This is largely because of a Florida company called MV Realty, which created what were called N-traps, is the terminology they used for them. And they were essentially 40-year listing agreements where they would, during the 2008 housing crisis and the recession, they would go to distressed buyers and say, you need $300 right now, right? So I'll give you $300 if you sign this agreement that I am essentially your exclusive listing agent for the next 40 years. And when people felt better about their property and the property values and all those things years later and had forgotten this agreement they signed for a 40-year listing, they would sell their houses and MV Realty would blast out of the woodworks and say, hey, we're their exclusive agent, we're entitled to that commission. And it was really a predatory real estate practice that was not responded to well. There were 7 states that filed, their attorney generals filed lawsuits against it. And so the result is a fair number of states, Oregon included, have adopted things that essentially restrict the ability to do NTRAP agreements, which means you can have a representation agreement for 2 years. And if your client wants to keep working with you at the 2-year mark and you go, hey, let's sign this thing up for another 2 years. Yes, keep going. But it can't be something where it takes no user input and you're just kind of leaving it quietly so that you can then blast out of your trap door and snag a commission off that end trap. Expected date, the new forms will be available for use. January 1st is the expected date. We are hopeful that that's the date that it'll exactly happen, but we've been disappointed in the past. So January 1st is what we've been told. Mentioned that once the contract has, or a deadline has expired, the contract isn't viable, but if parties move forward and include an extension by virtue of moving forward, is it still valid? Vanessa, it is a question that has never truly been defined at Oregon law, and I am of the opinion at a legal level it would not be valid. The reason why is under Oregon law, you have to have a contract in writing for it to be valid. Statute of frauds, essentially. Real estate contracts have to be in writing. You can do all kinds of oral contracting for stuff outside of real estate, but for real estate contracts must be in writing. So if you have a contract that expires, literally says this expires, and you proceed nonetheless, despite the expiration, that contract has been revived technically through implication, through what amounts to an apparent contract that's been created through implication alone. That's fine for all kinds of contracting. If I hand you $1 and you hand me an apple, we don't need to put it in writing that I have a contract to buy an apple from you for $1, because the act of me handing you $1 and accepting the apple, clear. We know what we're doing here. That's fine for a lot of stuff. For real estate, the statute of fraud gets involved. And in Oregon, our statute of frauds essentially says, if you don't have a contract that's valid in writing, that is one of the statute of frauds elements, so marriage contracts, that kind of thing, it's void. Not voidable, but just strictly void. Unless you get some sort of a memorialization of that in writing that has a strict explanation of the consideration involved in the transaction, something to that effect. But what that essentially means is you have a contract that for some period of time, it goes void, literally gone. And then when the parties put an extension on it in writing, they've kind of zombified it and raised it from the dead, and you now have a contract that once was dead but now is not. And that's really never how contracts were ever supposed to work at contract law. And so there are a whole bunch of questions that are just unanswered in the statutes and in the precedential court cases. Nothing has answered the question. So our stricter answer is we don't know. But the literal read of the statutes is once it goes dead, because it says void in the statute of frauds in Oregon rather than it is voidable, you don't have a contract anymore. And that extension, therefore, is not creating a new contract. You're amending something that is already dead, and it doesn't revive the contract. Best case scenario, and this is what we generally advise in the Oregon Realtors Library, is you would simply write a new counteroffer, or just an offer in general that is exactly all the terms you just had, but then modify the expiration date. Now, I know it sounds like a lot more work, but it essentially, by writing an offer or by writing a counteroffer that strictly says, incorporate all the language from that previous offer, but here's my new offer to you, it expires at a later date, so it's a valid offer. You have taken it out of the realm of a zombie contract and that whatever kind of curious thing that's going on there, and you put it strictly in a realm where it's a valid contract that's been established through reference or through essentially like a living document attachment of the previous offer. And so doing a counteroffer or an offer, or in the Oregon Realtors Library, we have Form 2.3, which is the late acceptance addendum, which basically is just a pre-drafted counteroffer that says, your offer expired. I'm so sorry. Here's my offer to you. It's exactly the same terms. I've just changed the expiration date. That makes it a valid offer in its own right, and there's no question of statute of fraud's validity at that stage. Patrick, going back to your question, in the short sale world, let's see how far back we go on this. Short sale, section 6. Whoop, there we go. Lien holder approval. Seller may provide written short sale approval, shouldn't say shall. In this instance, the reason why we essentially have it as a may in this case is that the seller is providing approval from all of the lenders, and then has the option to say yes or no to the terms that could change in this case. The problem if we just had that say seller receives approval of the short sale from the lien holders, we then move straight to seller has to deliver this approval to buyer, and we're off to the races on a short sale, is some lenders will provide approval with conditions and with additional pieces to it. And unless we draft the language in a very restrictive way that essentially says you can only accept a short sale if the lender approves exactly the terms of this, where you'd have to keep going back to the well to modify the contract before the lenders could approve it, having the seller's ability to say, look, the lender moved the contract in a way that I just can't accept, makes this as kind of a discretionary approval provision. It makes it somewhat more flexible in the short sale context. It is a valid option to say shall. There are other states that do it that way, but the way that we opted in this case was to say may, with the intent of essentially giving the seller an ability to double check the lender approval terms and say, are these good for me or not? And if the terms are good for that seller, great. If the terms are not good for the seller can basically say, we don't have approval because the lenders have modified the contract in a way that is unacceptable to me. Now, if the seller lets that contract fail because they don't like the lender's changed terms, they'll probably have their property foreclosed on. And so in the end, there's kind of a vested interest that the seller has in approving the lender's terms. But it is a back and forth where the seller has some degree of authority in that transaction. You are free to log off. Yes. We have reached our hour mark, and we're good to go. Credit has been earned. Congratulations. We're just answering questions in the background at this stage. So thank you for being here. We appreciate you. Oregon Realtors Forums updates, hopefully January 1st. Let us know if you have comments, feedback, or forms at OregonRealtors.org. All right, Katie, I guess we shut it down. We're good.
Awesome. Thank you so much, Nick. Have a great day, everyone.